Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. This is our trial skills series, and on today's lecture, we're going to talk about how to create your trial outline. So your case has been set for trial. You've done your pretrial statement, you've got your exhibits, you've got your witnesses, you have the information about the other side's case, and now you want to sit down and draft your actual questions and closing argument. So let me move this forward. Okay, so what is a trial outline? First of all, it's only for you. So this isn't something you file with the court. You don't share it with the opposing party. This is just for you to use during the trial. And this is your script. This is what you're going to follow during the trial, so you know what questions you want to ask and what arguments you want to make. So here are the components of a trial outline, and this follows trial procedure. So this is the same flow that's going to happen at a trial. First of all, you've got your opening statement. Then the petitioning party. So whoever filed the petition that is leading to this trial. Now, if you are at the divorce or custody establishment case, that will be the petitioner. But if you're post-decree, so you're looking for a modification and or enforcement of an underlying decree or order, then the petitioning party may or may not be the petitioner, because the respondent could also petition the court for a modification or enforcement. So it'll be whoever filed the underlying petition that is leading to this trial. They're going to be the petitioning party, and they're going to put on their case first. Excuse me. So they're going to put on their case first. And what they'll do when they have to put on their case is they'll call their first witness. And when they call their first witness to the stand, they're going to ask that question, or ask that witness questions on direct examination. So direct examination is very open-ended questions where you're getting the witness to tell their story. Once the petitioning party is done asking their first witness questions on direct examination, then the responding party gets to ask that witness questions on cross-examination. Once they're done with cross-examination, then the petitioning party they don't have to, it's optional. They can ask their witness questions on what's called redirect. So if anything came up during cross that they want to clarify or get some additional testimony on, that's where they would do that, here in the redirect examination. Now, the petitioning party, this flow for witness one, this will now happen if they have a second witness. So they would call witness two to the stand, and they would go through direct examination, cross-examination, and redirect. If they had a third witness, they would call. So all of the petitioner's witnesses get called at this stage, at least the ones that they are planning to present in their case in chief. Once the petitioning party is done with their case in chief, then it's the responding party's turn. So this is where the responding party would call their first witness to the stand and ask them questions on direct examination. Then once the direct examination is done, the petitioning party would ask the responding party's witness questions on cross-examination. And then the responding party could ask their witness some follow-up questions on redirect, if they had any follow-up questions to ask. Now, if the responding party had more than one witness, this is where they would call their next witness and follow this same procedure. Now, if the witness is the party themselves, so you're representing yourself, you don't have an attorney, and you're the petitioning party, and your first witness is you, well, then you would take the stand, be put under oath, and you would just start testifying on direct examination. There's no one to ask you questions, so you just get to give a narrative. And for that direct examination where you're testifying without a lawyer asking you questions, I suggest that you have a piece of paper in front of you with some bullet points. to help to guide you through what you want to talk about during your testimony. And then after you're done with your testimony, if you're testifying, then you'll be subject to cross-examination by the other side or their lawyer if they have a lawyer. And then once cross-examination is done, you would get to testify on redirect if there was any additional testimony you wanted to give based on what came out during cross. Same thing for the responding party. If the responding party's first witness is that party, they would take the stand and they don't have a lawyer. They would just testify on direct examination. They would be cross-examined, and then they could provide testimony on redirect if they wanted to. Now, once the responding party is done presenting their witnesses, the petitioning party has the option, they don't have to, of calling rebuttal witnesses to the stand. So if some sort of evidence came out during the responding party's case that wasn't mentioned during the petitioning party's case in chief, they can call a witness on rebuttal to provide additional evidence and testimony about something that came up during the responding party's case. Now, that could be the petitioning party themselves. They could retake the stand. In other words, it could be one of the witnesses that testified during their case in chief, or it could be a new witness. And keep in mind that presenting a witness on rebuttal doesn't always happen because of a lack of time. You know, if you only have a certain amount of time for the trial, you may not have time to call a rebuttal witness. But I wanted to bring it up because it is an option, and it can be very effective if there's something that came up during the responding party's case that you want to present evidence on. So if the petitioning party presents evidence on rebuttal, once they're done, then there's closing arguments. Again, in the interest of time, if there isn't a ton of time, the court may not allow closing arguments. If you run out of time and there's something you really want to argue in a closing argument, you could ask the judge to do written closing arguments with a deadline. But overall, usually the court can fit in 2 to 5 minutes per side for a close. So it is nice to have a closing argument written. Additionally, when you're drafting your trial outline, I suggest you start with your closing argument, because that's going to help you get clear about what evidence you're looking to present. What is the story you're looking to tell? And then you can come back and draft your questions for each witness once you've figured out that story that you're going to tell. All right, what is an opening statement? Well, an opening statement is a brief statement summarizing what your case will be about. However, it's not required. So you could waive closing argument. Excuse me, you could waive your opening statement. So here's an example. Today, I will present 2 witnesses who will testify about why it is in our children's best interest to award me sole legal decision-making. So this opening statement here, this example, it tells the court how many witnesses are going to be presented and what they're going to testify about and what the main issue is. So 2 witnesses testifying about best interests in relation to sole decision-making. And then, like I said, you could waive it. So you could just say, Judge, I'm going to waive giving an opening statement. If you've already filed your pretrial statement, the court's read it, like you don't necessarily have to give an opening statement. And if you have a really short amount of time for trial, you may be like, look, even though it's only going to take a minute or 2 to do this, I'm going to waive it because I want to preserve that time for my witness testimony. All right, so then we have the petitioning party's case. The petitioning party will call their first witness to the stand, and the petitioning party will engage in direct examination. So if you are the petitioning party, then draft direct examination questions for your first witness. If you are your first witness, then prepare bullet points of what you want to testify about. Then there'll be cross-examination. If you are the responding party, then draft cross-examination questions for the petitioning party's first witness. Now you may say, oh, I don't know who they're going to call to the stand first. True, you could ask them, Or you look at their list of witnesses, and if they have 2 witnesses listed, then you'll draft questions for both of them and can access those questions depending on the order that they're called to the stand in. So just understand you can be flexible. You don't absolutely have to know who they're going to call first. You can just create questions for each witness and then go to those questions when that witness is called to the stand. Now, as far as redirect examination, this is optional. And because you don't know exactly what's going to be asked on cross, you may not be able to draft any redirect examination questions. It will more be about, as you're listening to the testimony, as you're listening to what comes out on cross-examination, at that point, drafting your redirect examination questions for anything that you want to follow up on. So we've got a question here. It says, when you are the petitioner, it seems like you will be getting more time in the hearing. Is that the case? If you present evidence on rebuttal, then you potentially would get more time, but not necessarily. Let me scratch that answer and redo. So if you are the petitioner, you don't get more time. The court will most likely say, look, we have an hour for this hearing, 30 minutes to petitioner, 30 minutes to respondent, and the court clerk will keep track of the time. So if the petitioner wants to present a rebuttal witness, they still need to do it within that 30 minutes that they have for their case presentation. If you have a half day, that's 3 hours. Each side gets an hour and a half. So the petitioner would just need to factor that time into their case presentation, but they don't end up getting more time. Now, they get the last word if they're presenting a rebuttal witness. So they get to have the last word, so to speak, but that doesn't necessarily mean that they're going to win because they get the last word. They're going to win if their argument's persuasive, not necessarily based on how many times they say it. Okay, so let's go back to the slides. So again, you've gotten through, you're the petitioning party and you've gotten through your first witness. Now you're going to go to witness 2, same thing. Draft, if you've got a second witness and you're the petitioning party, you're going to draft direct examination questions for your second witness. If you are going to testify as your second witness, then prepare bullet points of what you want to testify about and take those bullet points with you up to the stand. For witness 2, if you are the responding party, then draft cross-examination questions for the petitioning party's second witness. And then again, for redirect, it's really not something you can draft ahead of time. You're going to need to listen to the testimony on cross-examination and determine if there's any follow-up questions you want to ask. So in this example, we're looking at the petitioning party having 2 witnesses. So they've finished with their 2 witnesses. They've finished their case in chief. And so now it's the responding party's turn. So that's when they're going to call their first witness to the stand. So if you're the responding party, you'll need to draft direct examination questions for your first witness. And if you are your first witness, then you'll prepare bullet points of what you want to testify about. After direct examination, there'll be cross-examination. So if you're the petitioning party, you're going to draft cross-examination questions for the responding party's first witness, and then potential redirect, optional, and you'll need to evaluate that during the trial. If the responding party has 2 witnesses, then this is where they would call their second witness to the stand, and the responding party will want to draft direct examination questions ahead of time for their second witness. Or if they are going to be their second witness, then they can prepare bullet points of what they want to testify about. Witness 2 would be subject to cross-examination. So if you're the petitioning party, you would draft cross-examination questions for the second witness, and then redirect, you'll figure that out during the trial. So then the petitioning party has this optional rebuttal opportunity. So the party that filed the petition, that is the basis for the trial, can call the same or new witnesses to the stand to seek to rebut evidence the responding party presented during the presentation of their case. The petitioning party calls their first rebuttal witness to the stand. Oh, that went in a different order. That's funny. The rebuttal witness one, there'd be the direct examination. So if you're the petitioning party, then during the trial, you may be evaluating during the trial whether or not you're going to call a rebuttal witness, because you need to see what the other side's case is going to, what evidence they're going to present during their case. So you may be creating these questions on the fly for your first rebuttal witness. If you are going to testify as your first rebuttal witness, then make some bullet points during the trial about what you're going to testify about. Rebuttal witness one would be subject to cross-examination. So the responding party is going to need cross-examination questions for them. You'll likely need to do this on the spot during the trial. And then there would be the optional redirect examination. Once the rebuttal witnesses have been called and testified, and that's finished, then it's time for closing arguments. And for a closing argument, you're going to look to weave your case facts and the applicable laws into a compelling and persuasive argument. Don't stop at your first draft, keep editing and revising. So write it and then go back to it and rework it and keep trying to make it as compelling and persuasive as possible. And then just keep in mind that there may not be sufficient time to present your closing argument, but you should still prepare one regardless of whether you actually get the opportunity to give your closing argument, because it helps you get so clear about what your case is about. All right. So just as a summary, keep in mind that your trial outline is only for you. You don't file it with the court and you don't share it with the opposing party. This is your script to use during the trial. Be flexible during the trial. Although you have this script, you're still going to need to listen to the testimony and react based on what the actual testimony is. The opening statement can be optional. It should be short. It's just a statement. It's not argumentative. The petitioning party goes first, presents their first witness, and for each witness, it's going to follow the same procedure of direct examination, cross-examination, and redirect examination. And then for the responding party's case, same thing. They'll call their witnesses and they'll follow the same procedure for each witness: direct examination, cross-examination, and redirect. And then there's the optional rebuttal witnesses by the petitioning party, and then finally closing arguments. Now, if you would like more information about how to draft questions for direct examination or on cross-examination, go to the trial skills course in the direct and cross-examination sections and watch those videos. You'll find more information there. So if you are the petitioning party, this is going to be your trial outline format. You're going to have your opening statement. You're going to do your direct examination questions for your first witness. And then at the hearing, you'll have the option of doing redirect examination questions. And then when the responding party calls a witness, you'll want to have cross-examination questions prepared for them. You have your optional rebuttal witnesses and then the closing argument. So everything in bold is what the petitioning party would draft in their trial outline. And then if you're the responding party, you do an opening statement, cross-examination questions for the petitioning party's witnesses, and then direct examination questions for your witnesses. And again, if you are your own witness, then you would do the bullet points about what you want to testify about, and then your closing argument. All right. So that is a summary of how to create a trial outline. Thank you so much for joining me today.